Esteemed participants of today's workshop who have joined from different parts of the country, ladies and gentlemen, good evening. We are meeting today to discuss, analyze, and understand the implications of the three criminal law bills introduced in the Parliament. As we all know, these bills are aimed at repealing and replacing the Indian Penal Code, the Indian, that is the Code of Criminal Procedure and the Indian Evidence Act. And as we all understand, these are the fundamental foundational texts for India's policing and the entire criminal justice system. And the proposed changes are going to be monumental, and they are going to have far-reaching implications for the functioning of the police. Now, we all are agreed on one thing, that the outdated colonial legal provisions that no longer serve the contemporary reality, some of them have to go. And we have to usher in progressive legal provisions to streamline our criminal justice system, our policing, etc., that resonate with the present day reality. At the same time, there is a fear that the new legislation will potentially unsettle our long-standing criminal law jurisprudence that have already been interpreted and settled over a long period of almost 160 years by the courts. There is a fear, a genuine fear among police officers that the new laws will reopen some of the settled jurisprudence to new interpretations, and that there could be the potential for creating ambiguity, confusion, and uncertainty. Now, a first reading of the bills generates plenty of concerns, unsettling questions about the bills. There are a number of drafting errors, discrepancies, contradictions, and even in some cases, some multiplicity of definitions that are likely to make police work rather difficult. And it is very crucial that we bring each one of these problematic provisions to the notice of the parliamentary committee. There is another major concern with all of us, that is about the renumbering, the reordering, and the reclassification of the provisions of these acts, which are going to have some very far-reaching and serious implications. I'm not going to list them here. I'm sure the subsequent speakers will be dwelling upon them in more detail. The specific purpose of today's workshop is to listen to police officers from different parts of the country to understand what are the practical implications of the proposed laws on some of the fundamental matters that affect policing. Like, for example, registration of FIRs, the concept of preliminary inquiry before registration of FIRs, the process of arrests, police custody, investigations, statements made to police, search and seizure, the admissibility of electronic records, and the procedure for collecting and marshalling of the electronic evidence. Now, we don't want to go into the philosophy or the politics behind the proposed legislation. Our endeavor today should be focused on studying clause by clause how the new provisions are going to impact police work. Let us stick to that. I consider that this is an opportunity for the Indian police to articulate and communicate its concerns and suggestions. The IPF proposes to prepare a detailed memorandum, which we can meticulously in which we can meticulously list out all the provisions that are likely to adversely impact policing, and also what are our suggestions for mitigating our concerns. So I request every one of you present today to debate, generate the ideas, and assist in preparing that proposed comprehensive memorandum that we propose to prepare for submission to the parliamentary committee. I must also bring to your notice that the IPF has very little or limited resources. So your active contribution is therefore extremely crucial in making this project a useful exercise. We also understand that there is very little time available, and we may have to finalize our memorandum within probably 5 or 6 days. So let us all put our heads together and prepare a comprehensive memorandum, for which I need the assistance of every one of you. Today's workshop, we have a very tightly built agenda. We have chosen some of the most brilliant and experienced police officers. There were many requests for including as speaker. I could not include everyone, obviously, because we cannot have a very prolonged discussion. Maybe if necessary, we can have one more program subsequently. So today we could not accommodate all the requests, but we have selected, in fact, we had already selected a few speakers, so we will stick to them. But there is also, at the end of these initial speakers, we also have a time slot available in which Dr. Sudhanshu Sarangi will be moderating a discussion, in which I would request each one of you to participate, and that is it. So we should make the best use of the time available today, and I would request each one of the speakers also, please make sure that you don't repeat one person who has already made a point. We need not repeat that point once again in the interest of, economy of time. So I thank every one of you for having taken out the time and for participating in this very important workshop. Hope we all have a very useful and educative session ahead. And also, I hope that we would be able to produce a well thought out memorandum which contains all our concerns for submission to the Honorable Parliamentary Committee. Jai Hind. Now, may I request the acting chairman, Shri M.L. Kumawat sir, to present his suggestions.
Thank you, Mr. Ramchandran. I will not repeat whatever you have said, but I will mention the objects and reasons given in the bill. Why actually these three acts which we have, IPCC, RPS and Evidence Act, are being replaced by these three new acts. The objects and reasons mentioned are to strengthen law and order, to simplify legal procedure, to provide speedy justice, and to secure life and liberty of the citizens. All for the purpose of providing ease of living for a common man. I think very laudable objectives and reasons are there. And for the first time, it is mentioned in the bill itself that community service has been provided as punishment. Other laudable provisions are summary trial, disposal of property lying in police station within 30 days, completion of investigation in 3 months, e-filing of FIRs, time-bound trial, only 2 adjournments, and trial by video conferencing, then many more. I have gone through a few clauses and also all the 3 bills. In fact, there are 3 bills. But I find that these laudable objectives will be difficult to achieve because we do not have infrastructure to achieve these objectives. Within 3 months, investigation has to be completed. Within 3 years, trial has to be completed. What about the cases which are already under trial? 5 crore cases which are there in the courts. And similarly, the number of vacancies that we have in the police stations. First thing, people will have to understand all these new laws, which are in fact almost they are topsy turvy. People have to remember the new act, new clauses, what we call them now. And another thing which has to be kept in mind, whether these new offenses are in conformity with criminal jurisprudence, which is the most important. Uh, I have gone through a few clauses, and my comments and observation about 7 of them are like this. It is mentioned that for the first time, terrorism has been defined. In case we go through the UAPA, that is Unlawful Activities Prevention Act 1967, Section 15 very clearly mentions what is a terrorist act. So once terrorist acts are mentioned, terrorism is already defined there. A special act exists for, which is very comprehensive. There are 53 sections. So my suggestion here is that government should make should not include this terrorism section in the IPC and let UAPA, which has procedural sections also, provisions in the act should continue, because there are many things which do not find mention here in the BSS, what we call Bharatiya BNS, Bharatiya Nyaya Sanhita. Similarly, another one is about organized crime. It is claimed that organized crime has been defined. Organized crime is already defined in Makoka, and many states governments have also adopted or enacted their own laws. So here my suggestion is, again, this can be made a central act, just like NIAs. I mean, certain acts which are like UAPA, which is applicable throughout the country, because again, Makoka has 30 sections, defines organized crime very comprehensively in section 2E. And it also mentions trial by special court, authorization of interceptions, annual report of interceptions given to assembly, protection of witnesses, punishment for public servants failing to discharge their duties. All these things do not find mentioned in BNS, Bharatiya Nyaya Sanhita. And then another provision which is there, that police remand may extend up to 90 days. I had discussed with my many learned friends. Let me mention, because he said that I may mention his name. ML Sharma, who was in CBI for almost 18 years. He said it will be very draconian in case we have police remand up to 90 days. And there will be many custodial deaths in case this provision continues in the new bill that we have. 90 days police remand is too much. And then about mob lynching. For the first time, mob lynching has been included as a clause in the BNS, Bharatiya Nyaya Sanhita. Punishment is up to 7 years to life. We do not understand to whom 7 years punishment will be given and to whom life imprisonment will be given. It is not clarified there. Uh, then there are two clauses which are very important, which relate to health and life of the citizens, which I think is the most important, health of an individual and the life of an individual. Clause 272, which was earlier IPC section 272. It relates to adulteration of food and drinks. It is very interesting to know that punishment which was included in 1860 Act, 6 months to fine. Many states like Rajasthan has increased it from 1 year to 7 year punishment. But in the BNS, it is only 6 months. Odisha state, very interesting, Odisha and Uttar Pradesh, they have amended this and punishment is a life imprisonment for adulteration of food and drinks, food or drinks. So here in the new Samhita, it is only just 6 months and fine or fine. Similarly, adulteration of drugs, I think, which is a very serious offense. Uh, but again, punishment provided in BNS is only 6 months or fine. Rajasthan has again increase it to 7 years. And Odisha and Uttar Pradesh, they have life imprisonment for these offenses. Then the most talked of section is sedition, 124A. If one reads this section and if one reads section 150, you do not find any difference. Rather, it has become more draconian. And many words in this, like subversive activity. Anyone who excites or attempts to excite subversive activities. Now, subversive activity has not been defined. It also mentioned for the first time who endangers sovereignty. Sovereignty, like justice, these are concepts. These have not been clarified anywhere in the Constitution. So I think this, again, Section 150 is likely to be misused by powers that be through police. So I think we must pay attention to this. There's 150. And very interestingly, I was reading uh, Prime Minister's Economic Advisory Council chairman, Mr. Vivek Debroy, has also commented on this very section. This is very ambiguous. So I think we will discuss it more comprehensively, and IPF will give some suggestion to the standing committee of the parliament. Thank you very much, and for giving me this opportunity to speak, Mr. Ramchandran. Thank you. Jai Hind.
Thank you, sir. Can you hear me?
Yes, sir, I am able to hear you.
Thank you, sir. Now I request former DGP Uttar Pradesh, Shri Sulkhan Singh, to make his presentation. He will be speaking on the specific provisions of the Indian Penal Code and the Bharatiya Nyaya Sanhita, which the corresponding bill. Over to Shri Sulkhan Singh.
Hello, sir. Can you hear me, sir?
Yes. Yeah.
At the outset, let me thank Mr. Ramchandran for inviting me. Since time is very little at my disposal, so I'll speedily go through. It's heartening that after a period of 163 years, the IPC, the main penal code of India, is being replaced by a new code. But as Mr. Kumaut has said, most of the provisions had been just retyped. There is not much of a difference between the old IPC and the present Bharatiya Nyaya Sanhita. Some sections have been clubbed together. The definition sections were about 52 in IPC. They have been reduced to 1 now. So that way some sections have been reduced, but exact wording continues in most of the sections. So there is no paradigm shift in this legislation, as it is probably aimed, and at least is said so, that these are the aims of this law. So firstly, to call it a Nyaya Sanhita itself is a misnomer. It is a criminal penal law which provides for creating offences and punishment for it. So definitely the penal code or Danda Sanhita is still most appropriate. So it should be better if it is kept as Danda Sanhita only, say Bharatiya Danda Sanhita. Then once we were reconsidering the whole penal law, we must have included latest penological thought and discussions, researches, and streamlined some punishments and some definitions. The Law Commission itself have recommended in their latest report, probably it was in May that they have given the report 262, abolition of death penalty. But I find that death penalty is there with vengeance. So I consider death not as a penalty, it is vengeance, it is a revenge. It's a worst kind of revenge. State taking revenge on a person is not very good governance. So I will definitely recommend that the penalty of death should be removed from the statute in India. It is high time that is done. The next offense, that is a highly colonial and a sort of dictatorial government that they did during British period, that is forfeiture of property. Whomsoever they punished and they wanted, they forfeited his property. This was particularly with the Nawabs and the Rajas and Jamidars. It was only to put them to their proper place that forfeiture was introduced as a punishment. In an independent nation, in a free society, forfeiture of a property of a convicted person has no place basically. So it should be done away with. The next is rigorous punishment. Rigorous punishment means a punishment with hard labor. Forcing some person to do labor or to do something itself is highly indignified. It cannot be punishment to humiliate somebody, to do certain things against his will. Those who do some work in the prisons, they get some reward in the form of remission, and those who do not work, they will not get that remission. That should have been enough incentive or disincentive. And but keeping rigorous imprisonment as a form of punishment is not proper basically. So it should be done away with. Then now I'll come to sentencing provisions. In most of the parts of the proposed BNS, as in IPC, the punishments have been provided like which may extend to so much, and or fine or both. This sort of uncertainty and very loose discretion to judges has been found upon time and again by different committees, commissions. Even Supreme Court have suggested some sort of sentencing guidelines. Justice Malimat Committee did suggest sentencing guidelines. The Administrative Reform Commission, probably the second ARC, they also suggested some sort of guidelines for sentencing. Nothing comes in the IP, this BNS. So I propose a sort of minimum and maximum for every punishment, for every penal provision, a minimum and maximum. So a very limited discretion will be given to the sentencing judge, and he will have to sentence between those limits only. Then I'll come to most misused provisions of the law IPC, particularly in the light of judicial discussions and judicial orders. One of these is 124A. In Kedarnath Singh case, Supreme Court dealt with in detail with this law, but did not strike it down. They gave very pious words, but never struck down this law. This 124A was definitely a very draconian law. Not only draconian, it was highly dictatorial. Just to say that you incite disaffection. How can inciting disaffection be a crime? Inciting disaffection against a government is a right in democracy. So in section 150 that they have substituted, the inciting disaffection and such dictatorial words, they have been done away with, of course. But the provision that sovereignty and integrity of India, feelings of separatist activities, these sort of loose words, they open this law to great misuse by police and of course by political bosses. So these words encourages feelings of separatist activities or endanger sovereignty or unity and integrity of India. They should be removed with. And then punishment shouldn't be life or 10 years. Maximum punishment up to 7 years would be enough. So this has to be recommended that way. In coins and currency section, that is chapter 10, there has to be some provision that people refuse to take except legal currency. The moment something is done, like this 2000 rupee note, its circulation is still valid, but its printing has been stopped. The shopkeepers are refusing to accept it. This happens with coins and other currencies also. So a separate offense to be included, that whosoever refuses to accept a valid coin and currency should be punishable with that. Then public servant, in the chapter of public servants, a provision should be included for those public servants who incite or take sexual favors for doing or not doing certain official things. There was a talk to include this favor in Prevention of Corruption Act also, but it would be better if it included in chapter 12 straight away in this. Then I'll speed up because there is little time left. I'll come to section 255, 256, 267. This punishes a judge who passes a wrong order. This is a very sort of serious section, which is causing concern all over judiciary and all right-thinking people. To punish a judge or a magistrate who wrongly commits a person for trial or who passes a wrong order with 7 years of imprisonment is just sort of suppressing judicial independence and free action. So section 255 to 66 should be immediately repealed from this law. They should be removed from this. Then there is a section of fraud and forgery. I recommend that the word dishonestly and fraudulently, wherever they come in, they should be removed. Forging a document only for dishonest use or for fraudulent use is very difficult to prove and sort of get a conviction. If somebody forges a document, creates a false document, that itself should be an offense. And if he uses for fraudulent purpose or for dishonest purposes, that should be another offense. So that way, suitable modification is required in this. Then gross, detailed, and sort of drastic amendment is required in section 350 and section 351, and also in defamation case. For protecting free speech, criticism of false beliefs, dogmas, criticizing classical books, so-called even religious books, historical personalities, or any wrong superstitious beliefs which a person feels is wrong. So it should be allowed and it should be protected in the IPC within suitable provisions. If this is not done, how can there be an improvement in religious beliefs, religious practices, social practices? How can dogmas be done away with? How could a Kabir write कांकर पाथर जोड़ के मस्जिद लियो बनाए? If you can't criticize people, if you fear that somebody's religious feeling may be hurt, see, a religious feeling can be hurt for anything. It's a very wide thing. So a genuine, civilized, decent, and cultured criticism, not in a vulgar or humiliating, insulting words, should be fully protected, so that this India remains a free society. The purpose of law is to create a free society where people are not afraid of talking decently, criticizing decently. So the whole philosophy of law, but in this Bharatiya Nyaya Sanhita, has to be to protect first fundamental rights. We are improving our citizenry. After a long period of political subjugation, our country is breathing a free air. So it has to be protected. People should not fear. They should not be under fear that anything they talk will be subject to a police FIR. So particularly these, what I have mentioned, and any other provision where there is a loose, definitions are not very clear. They must be clarified and brought within straight jacket. I'm writing a note. I'll give it to parliamentary committee also, and give it to Mr. Ramchandran also. I'm almost half through in typing. So where the detail section by section comments have been given, but certain sections which are being misused, like section 306, today's 306, that is abatement to suicide. Any person doing anything lawful, and if somebody is taking offense to that and commits suicide, a criminal when cornered for being arrested, many a times criminals have committed suicide when they were cornered during arrest. Is it abatement to suicide? So explanation has to be added in section 105, 106, that doing anything which is lawful is not a abatement. Abatement should be only what is illegal to do. So that protection has to be given to these things. Then section 304B, 304B, now section 79. There is no time limit for how long this offense can continue to be committed. Like for 304B, 7 years for 304B, there should be some time limit, like say 3-4 years for 498A, that is 79 BNS, and 304B, that is 79, 498A, 84. So a small time limit should be there. Further definition of family should also be explained there only. Everybody becomes a family. Many a times Supreme Court have commented that implicating Saas, Nand, Nandoi, everybody else is not fair. So although judicial thought that has gone into various sections must be included in present definitions. One thing that was very glaring to me was unnatural sexual offense. Section 377 has not been given any substitute. So unnatural offense, that is sodomy, forcible sodomy, or under threat or fear or some inducement against the will or consent, it must be included either in sexual offense chapter or in offense against body. I have recommended it after 122, section 122 BNS, to indulge in unnatural sex, which is not covered under rape, under fear, without consent, without will, under force or duress, or under influence, or under deceit, or under promise of employment, or any other such thing, should be made a punishable offense, maybe sodomy or some other proper word, and should be stiffly punished, like say a minimum of 5-6 years, and may extend to 10 years also. So that has to be included in this. And organized crime, as Kumar sir has said, organized crime should be removed from here. Terrorism Act offences should be removed from BNS, and they should go to proper place. In UAPA's Chapter 4, 5, and 6 provide detailed guidelines, detailed definitions for terrorism acts. So they are enough, and there is no need. In fact, rather it will create confusion. Similarly, in 109, 1010, that is organized crime, either central should pass a common organized crime law or leave it to states to make their own laws. We did it in UP in 2018. A law was passed, and unfortunately, that law is still lying with the government of India for presidential assent. So that sort of urgency, when they are the same governments, at center and at state, is really perplexing. Anyway, but these will definitely create confusion in charging and registering the cases. So they must be removed from here and taken to the proper special laws. Thanks very much.
Thank you. Thank you, Mr. Sulkan Singh. Thank you very much for that very comprehensive insight into the IPC. We will, of course, come back to the IPC after a little while. Now, I would request Sri KP Singh former DGP Haryana to make his presentation. He will be speaking on the CRPC, that is the BNSS, Bharatiya Nagrik Suraksha Sanhita. Thank you.
Thank you very much, sir, for giving me the opportunity. I directly come to the recommendations without wasting time. The first recommendation from my side is to include commissariat system in the CRPC. The provision of metropolitan area have already been deleted from the CRPC, but there is a case to include commissariat system of policing in the CRPC. The second recommendation is about, am I audible, sir?
Yes, yes, of course.
The second recommendation is about special executive magistrate in clause 15. They have mentioned that SP and above rank may be appointed as special executive magistrates. Whereas when special executive magistrates are appointed, normally gazetted officers of other departments are appointed as special executive magistrate. So this rank may be lowered to the level of deputy superintendent of police or equivalent. The third recommendation is about handcuffing, sir. Clause 43.3 restricts the scope of the use of handcuffs only in certain eventualities, whereas Supreme Court guidelines gives unfettered power to a police officer to use handcuff for the first time when he is arresting a person at his discretion. And later on, after producing him before the magistrate, if he wants to handcuff, he should take permission from the magistrate. I think we have limited the scope of use of handcuffs by the provisions of section 43.3. So we should include the guidelines of the Supreme Court as it is. They are broader than the guidelines given in section 43.3. Or else, if we want to continue with it, we should add the following words at the end of section 43.3. That is, or who may harm the police officer or inflict self-harm or attempts to escape from custody, irrespective of the nature of offense in which the offender is arrested. The fourth recommendation is about medical examination during police remand. It was a safety cover for policemen against allegations of torture. So I think this provision, which was there in the old CRPC and have been omitted in the proposed bill, we should include it, that medical examination of an arrested person on police remand should be mandatory after every 48 hours. My fifth recommendation is about executive magistrate to take security for keeping peace. In clauses 171 and 172, subclause 2, they have replaced the word executive magistrate or magistrate with judicial magistrate, meaning thereby all the actions for taking security for keeping peace now will be decided by the judicial magistrate. I think it will be too much. The judicial magistrate do not have time, neither it is their priority, and the executive magistrate is responsible for maintaining peace. Therefore, we should change this word judicial magistrate to magistrate, simple magistrate or executive magistrate. FIR on written statement. In clause 173, subclause 1, after the word orally, the word or in writing may be added in the context of giving information to police. Somehow it is not there, and it gives an indication that if a person is submitting written statement for registering FIR, then it will not be taken. Preliminary inquiry has been introduced under the provisions of clause 173.3. This whole paragraph need redrafting. In fact, after Lalita Kumari's case, the court directed that in every case, there should be registration of FIR if a cognizable offense is made out. But here in 173.3, they have made a provision for preliminary inquiry with the permission of the Deputy Superintendent of Police for offenses which are punishable from 3 years to 7 years. I think there is a case for having preliminary inquiries in some of the offenses. So we should redraft this paragraph, and I am reading the redraft. if the information relating to commission of a cognizable offense in the following matters is received, the officer in charge of the police station, instead of recording FIR at once, with the permission of an officer not below the rank of Deputy Superintendent of Police, may proceed to conduct preliminary inquiry to be concluded within 14 days to ascertain whether there exists a prima facie case for proceedings in the matter or otherwise. And the offenses are matrimonial disputes, domestic violence, petty family feuds, financial dispute of civil nature, accident without injury or with simple injury, or any other matter in which fine is an alternative punishment. Only in these cases, preliminary inquiry is justified. If we will give unfettered power to police to conduct preliminary inquiry in all cases where punishment is 3 years to 7 years, then I think it is going to be misused and it will be a cause of harassment to public. We should provide for preliminary investigations, preliminary inquiries, but only in selected petty offenses. The 8th recommendation is about prosecution of public servant without sanction. Clause 175(4) provide that the judicial magistrate may take cognizance of a complaint made by a superior against a public servant regarding his discharge of official duties. It is, I think, in violation of the protection given to the civil servants or public servants under old 197 CRPC. Secondly, this paragraph here is out of context. Here we are discussing investigation. So where the question of judicial magistrate taking cognizance come here? If it is to be provided, it should be provided in the chapter where judicial magistrate take cognizance. But I am totally against it. The protection available to the public servant should be available. And we should not give this power to superior officer to make complaint against a public servant and the judicial magistrate taking cognizance of that without prosecution sanction from competent authority. 9 observation is about duration and timing of police remand. In clause 187(2), a period of 15 days police remand in whole or in part have been provided. It is qualified that this 15 days remand will be available for police only in the initial 40 days or 60 days of custody. I think here our powers to investigate are compromised if we allow this provision to continue as it is. I think 15 days period is too short a period for heinous offenses involving very serious investigations, and especially when the co-accused are absconding. After 15 days, you have no right to take the person on remand. Whereas if the person is arrested, another co-accused is arrested after 30 days or 40 days, you need to confront him. You cannot take that person back on police remand. So I think here we should say that the remand period in heinous offenses may be increased from 15 days to 30 days at the discretion of the court. And secondly, this period of this remand period of 15 or 30 days should be available throughout the period of custody of that person. The condition that it will be availed only in the first 40 days or 60 days, I think is not justified, and we should write about it. A case is also made out to increase the remand period from 15 days to 30 days, as I've already mentioned, and a proviso may be added to this effect after this section. Shri Kumawat referred about the ambiguity in clause 187(3) regarding availability of police remand for 90 days or for 60 days. Sir, it is, I think, a miss. It was there also in the old CIPC, but they omitted a phrase which gave this ambiguity. They omitted the phrase other than in police custody. The magistrate have power to remand a person to 60 days or 90 days, and that is judicial remand. But here, deliberately or I think by mistake, they omitted the word other than in police custody. So I think if they introduce the words other than in police custody in clause 187(3), the ambiguity would be addressed. Plea bargaining. Plea bargaining was introduced in the CRPC with big fanfare that it will reduce dependency and all that. But the reality is that hardly any case is plea bargained throughout the country. And the reason is that these provisions are impractical. The tag of conviction is there, only the punishment is reduced. The person has to pay compensation also. When we recommended the provisions of plea bargaining, we wrote this whole chapter and recommended to the government. I was associated with the initial drafting committee as expert consultant. So we wrote it again, and I think there is a need to write back this concept if we at all want that people should use it. The conviction of tag, or at least the disqualification attached with the conviction should be removed. And secondly, release on probation should be the remedy. Already, offenses are punishable up to 7 years. The offender can be released on probation by the court. So why not? He can be released on probation through plea bargaining also. Victim compensation. The definition of victim, which has been given in section 2(1) subclause 10, is very narrow, and it need to be expanded. It need to be expanded to include if the person or accused person has not been charged, even then the victim of crime will be compensated. The definition of victim, which has been given in section 2, I read it, that it will be only recognizing the victim if a person has been charged for the offense. There is a need that this definition should be expanded. And secondly, who will identify the victim of crime and the paying capacity of the accused? In chapter 13, relating to investigation, this duty should be cast upon the investigating officer, that when he is making other investigation, he should also write a paragraph about identifying the victims of crime and the paying capacity of the accused person. Otherwise, from where the court will gather information about them. Misconception about commutation. Section 475C needs a review. Commutation means changing the nature of sentence, whereas in clause 575C, it is prescribed that sentence of 7 years may be commuted to sentence not less than 3 years. It is not commutation, sir. It is remission then. So this misconception about the concept of commutation need to be removed. Compounding of offenses. The list is very short. The list need to be expanded with more provisions which may be made compoundable. At least all offenses where punishment is up to 2 years or where punishment is up to with fine, they all should be compoundable offenses. Secondly, in clause 359(2), mention about clause 86 of the Bharatiya Nyaya Samhita has been mentioned, whereby miscarriage, causing miscarriage of an unborn child has been declared as compounding offense. Sir, this chapter is to protect the right of the unborn child, and even the mother who is aborting a child is to be punished under the provisions of this chapter. So there is no case where this offense should be compoundable at the option of the mother. The protector of the unborn child is the state, and state should not allow compounding of these offenses. So these were some of my observations, sir. There are 15 more observations. Because of paucity of time, I am not able to discuss them here. I will send them in writing to Shri Ramachandran, sir, and for the benefit of others also. I conclude here. Thank you very much for giving me the opportunity, sir.
Thank you, Dr. K.P. Singh, for that wonderful exposition. I'm so happy that you have touched upon quite a large number of aspects. Now I go to the next speaker, Shri Umapati Sataru, former IGP, Andhra Pradesh. He will be speaking on the Indian Evidence Act, that is a Bharatiya Sakshya Bill. Umapati sir.
Sir, good evening to all the senior officers and our members. This Evidence Act, from the definition clauses, they require a lot of changes, sir. And first of all, the most dangerous section that has been included in the CRPC, as K.P. Singh sir said, is about that 173 clause 3. 173 clause 3 will be terrible if it's allowed to be continued, because that would really vitiate all other parameters of the Indian penal code. Because once you don't register, you don't scene of crime, etc., all that gets shattered. So that just to say, supplement it, sir. And also about this act, the evidences, the definition clauses. What I have seen in the definition clauses is they have not gone into the details. Some of them have just simply reproduced the definition clauses. And if you go to the definition clauses, the computer definition to be replicated, actually they have not used the same wording as that is in IT, and the digital signature to be redefined as per the IT Act, and the experts need to be elaborated as per the illustrations. In the experts, if you present proposed bill, they have not put several experts. They have not. They have put some illustrations which were already existing in the previous Evidence Act. For example, the experts definition include the experts of computer evidence. In fact, coming the computer evidence itself, you have very large number of experts. Like, for example, you have the Global Information Assurance Certification, that is Global Information Assurance Certification, GIAC, Advanced Smartphone Forensics, Certified Digital Forensic Examiner, Certified Forensic Examiner, Computer Hacking Forensic Investigator, and Certified Forensic Computer Examiner, Certified Computer Examiner. These are the words that are now across the world. These are the experts who are now examining in this new regime of the computer crimes across the world. And also the other crimes, other experts who are to be included, or the forensic medicine. Very surprisingly, we have not seen the forensic medicine mentioned anywhere. All the postmortems, either in the 302 murder case and all, they're done by the forensic doctors. And if you don't, they have been left out. Similarly, the forensic auditors in all these multi-level marketing offenses, the forensic auditors play a vital role. And also, it's not mentioned about the geospatial mapping experts who are required to map this mines criming of mines, illegal mining across the country, the geospatial mapping experts, and the IRSA maps also to be included, and the psychosocial experts. That wording has to be included because Juvenile Justice Act says so. When an offender is, when a person is, that is CICL, child in conflict with law. And also the other experts, as per the POCSO Act, which are the special educators and the translators, that's also not included. And more particularly, there was a discussion in our group that is about motor vehicle inspectors. Let me reiterate, sir, all motor vehicle inspectors are been given training, and they undergo the motor vehicle rules and act, and also they undergo the insurance rules, and their reports are very much needed by the MACT, Motor Accident Claim Tribunal. In fact, most of them will be asking for MACT claims, and they require the certification also. So that is also not included. And parallelly, if you see this section, earlier former section 293 CRPC, now the proposed bill is 329. 329 actually it has not been amended at all. 329 is simply kept as it is without being changed. And 329 is like it's a main master section, 329. And it is supported by this clause now 39. First of all, we must again come back to this section and clause matter. We should not say clause 39 against subclause. We say section and clause. Actually, the former 45 and 45A, that is the evidence, that the expert evidence, that has now become clause 39. And that also should be re-amended to include the Criminal Law Amendment Identification Act, Criminal Identification Act 2022, which in turn had also dwelt on this former section 53 and 53A of the CRPC, the present clause 51 and clause 52 of the proposed criminal procedure bill. And these things are not mentioned in this 45 and 45 in the elaborated. And in the evidence part of it, when we go into the details of this evidence, these definitions are not included in the evidence. So if they include in the evidence, the expert evidence, then they're called experts. Then it becomes admissible evidence. So the whole Evidence Act, it also talks about admissible evidence, inadmissible evidence. When we say admissible evidence, all these are mentioned. If they're mentioned in these clauses, then it becomes admissible evidence, because automatically they're appointed by the governments of the concerned state governments and union territories. Once they're appointed so-and-so as expert, that means it's admissible in evidence. A needless cross-examination will be there in this coming in this particular Evidence Act. If we go further into Evidence Act, we have also seen how this oral evidence, for example, section, if you take the oral evidence in this bill, the same section 60 has been replaced here, but to be seen, to be heard, to have heard, to seen, and to be perceived. But then the oral evidence is not included actually. If you see, take 161 clause 3 CRPC of earlier CRPC, former CRPC, there is audio video recording of evidence. And the audio video recording of evidence, that is not taken into consideration either in the new proposed bill of section 60. That is the new proposed bill. It says our old section 60 is now called it's called 65. It's called 65. The oral evidence section. No, oral evidence section is called 60. And it's called Oral Evidence Act. Oral Evidence Act is now called 55. The clause 55. So oral evidence is the most important evidence in any criminal trial, and that oral evidence which is recorded, audio video recording was also there, and also the audio video recording by the magistrate. In most of the cases of the rape cases, we have got the audio video recording done. The statement has to be recorded by the magistrate. That's a mandatory. When a mandatory provision is included, that particular to be reflected back into the oral evidence in section 60, that means proposed 55, that has to be there. Luckily 65B, which is supposed to be electronic evidence, 65B has got quite a point. But the dying declaration, if you take the dying declaration section, former section 32, and it is kept as it is, but in the dying declaration, you have lots of now new mechanisms have come where they are recording audio video recording, and that kind of provision is not included in this. In proposal that is called 26 of the evidence bill, clause 26, that has to be added. That is, suppose if it's recorded by a magistrate or it's recorded by a doctor, and in the presence of the doctor, it is he is also audio video recorded, and doctor says he is cogent and is cognitive and his speech is coherent, then in such cases it should be taken as an pakka evidence. If this has to be also extra, that provision has to be made into proposed 26 of the Evidence Act. That means former 32 of the Evidence Act. Then when we come to intention preparation, actually the whole Evidence Act starts from the section 8, the old section 8. Now the new section, it's called section clause 6. That's called motive, preparation, and previous and subsequent conduct. These are the essences. It's called, I always used to refer them by IPC, intention, preparation, and commission. If the intention, preparation, commission also form part of the FIR. In the FIR, it says they have confabulated, they have done like this, they have done. So FIR also has got these provisions of intention, preparation, commission, and that is reflected in the Evidence Act in the proposed 6, but it has not been elaborated to include those terms, preparation, previous and subsequent conduct, and what is the evidentiary value of the previous and subsequent conduct is not mentioned again in the admissibility of evidence. So the one side you say that there is this provision is there, but other side, when the matter is admissible, what is admissible is actually defined. In that, it is not again mentioned about it. For example, suppose let's take a case that previously they attempted to kill him, but they could not materialize. Subsequently, they again planned and killed. So what was the previous conduct? previously attempted to kill him. There was another case of 307, former 307. Now it has become now 302. But that has to be also to be added into this admissibility of it. That is called section 8. That's a basic section. And when we come to other sections of section 62, the documentary evidence, that is old section 62. Now new section, it is called it's called clause. The clauses are getting more confused because there's now the old section 62 is now clause 57. Clause 57, the primary evidence, the secondary evidence. In the primary evidence and secondary evidence, none of the new things, that is the document, whatever we are saying, the document, that document is not reflected here in this secondary evidence. When we say that new document has been, lot of changes have come into new document including electronic document and all that, it is not finding place in section, in the proposed section, proposed clause of proposed clause of 57 and 58. That's called primary evidence and secondary evidence. So this has to, again, secondary evidence, primary evidence are the main issues. Whenever you have a documentary evidence, the entire punishment will be coming on that aspect. So there is an explanation given in the primary evidence when an electronic or digital record is created, stored, and all that is given. But it is treated as a document. That document, whatever it is treated as a document, that has also one word should be added. Whatever has been defined as a document is also considered as a primary evidence. That word also should be reflected here. And coming back about the former 150, 151, when the see, if you go to POCSO Act, the questions are asked by the judge. The advocate has to propose the questions to the judge, and the judge should ask the questions to the victim. And that is that provision is there. Similar provisions are there in the our Evidence Act. The former, if you take the former 114A and also 53A, and these sections, they are very important as far as the conviction in the rape case is concerned. But then they have simply merged about 114A into this. That is called now 114A is now has become 1 second, sir. 114, yeah,
Umapati,
114.
Umapati,
Yes,
sir,
sir.
can you please conclude in 2 minutes?
Yeah, yes, sir. It's over, sir. It's I'm one. Yeah. These things, because whenever you are asking for a trial, 114A, this becomes presently 120. Presumptions as to absent of consent in certain case of prosecution for offences. Very important section. But this section is, again, nothing is mentioned about this clarity in as far as it's concerned in this 53A, 114A. And this presumptions ke liye, actually, you should not ask the questions like that. There is a section in the Indian Evidence Act, Former Evidence Act, that's called 151. It's called, Former 151 says, indecent and scandalous questions and questions intended now insult and annoy. That's called 151 and 152, former IEA. Now they're called 154 and 155. They have to be amended suitably so that they don't cause unnecessary annoyance to the witness. It's entirely, you could see, sir, any Evidence Act, they say that they annoy the witness so that you would be shattered and they somehow they will not be able to speak, or they will become, say, fearful of speaking out. So this is how I feel. So I've also sent it, sir. I will also send it through a computer, through a internet to you, sir, to a mail about all these new inclusions that are to be made in the Evidence Act. Thank you, sir. Thanks for giving the opportunity to me.
Thank you so much. And I would request you to please write them down clause by clause and then give it to me as soon as possible. Okay.
Yes, sir.
Thank you. Thank you.
Thank you, sir, once again.
Now,
sir, this former KP Singh sir has said about this. Sir also said about this. And 293 के लिए थोड़ा ध्यान रखना है sir. Former CRPC का.
Yeah, sure.
That's the present expert evidence का 329, clause 329. My request to KP Singh sir, 329 of the proposed clause of CRPC, उसमें बहुत सारे experts का नाम लिखना है sir. Thank you, sir.
We are running a little
Thank you,
behind.
sir. Good day, sir.
So may I now request Shri K. Ramanujam, former DGP Tamil Nadu, to make his presentation.
Thank you, Ramachandran. Can you hear me?
Yes, sir.
Good evening, everyone. The plug is being pulled on the 3 criminal major acts most of us studied and applied throughout our career. They are to be replaced by new acts. As the saying goes, the old order changes, yielding place to new. But is this new order all that different from the old order? That is the question I would like to examine. I'm not going into the merits or demerits of the individual provisions. In the new acts, the sequences of provisions have changed compared to the old acts. Some new provisions have been made, most of them salutary or necessary. But the old and the new acts are broadly the same. According to one count, IPC will have 22 sections deleted, while 8 new sections are to be added. There are 175 amendments, but not all of them are radical changes. For instance, the phrase unsoundness of mind is sought to be replaced with mental illness. This change has been made in 18 places and counts as 18 amendments. When substantive changes are few, where is the need for new acts when changes could very well have been made in the old acts by adding new provisions, deleting obsolete ones, and making amendments where necessary? Imagine what will happen now. Lawyers, judicial officers, police officers, and law students will have to learn the new sections. Even if the provisions of the new sections and the old sections are identical, they will have to learn the new numbering of sections. Culpable homicide, which was section 299 IPC, will be section 98 BNS. Section 376 IPC covering rape will be section 63 in BNS. The familiar section 27 of the Indian Evidence Act becomes proviso section 23(2) of Bharatiya Sakshya Adhiniyam. One cannot at the same time afford to unlearn the old act and sections either, because they will apply to cases registered earlier and still pending. Remember, there are 1,059 sections in the old acts and 1,060 sections in the new avatar. There will be totally 2,119 sections to contend with. Is all this worth the effort, considering the fact that the changes are not so radical or wholesale, especially when the drafting leaves much to be desired? Nobody reads law for entertainment. Nobody reads a law for entertainment or for intellectual stimulation, but one may be tempted to make an exception in respect of the Indian Penal Code or the Evidence Act to savor their precision and conciseness and the numerous illustrations. How do the new acts measure up to the old ones? Once Henry Kissinger wrote a speech for President Nixon, some staff in the White House made a few changes in the speech. When he saw this, Kissinger was livid and said, "This is like buying a painting by Picasso and then hiring 4 house painters to improve upon it." No disrespect meant for house painters, and definitely none to the eminent persons chosen to undertake this momentous task of revising the codes. Still, we must take note of the discrepancies, inaccuracies, and the not so felicitous expressions. IPC says, I'll just touch upon a few illustrations. IPC says movable property includes corporeal property of every description except land, etc. BNS omits the word corporeal. Corporeal means materialistic or tangible property. When this word is omitted, will movable property include intangible property like intellectual property? If so, can the concept of theft be applied to patents, copyrights, and trademarks? Or is the omission of the word corporeal inadvertent? Both IPC and BNS say it is rape if a man has sexual intercourse with a woman below 18 years of age, even if it is with her consent. The IPC provides an exception by lowering the age limit to 15 when the woman is the wife. BNS replicates this exception, but changes the age of the wife to 18, saying sexual intercourse with the wife, if she is not under 18, is not rape. Is this exception necessary at all when the age limit has been raised to match the age limit for any woman, whether she is the wife or not? a redundant and pointless exception without taking note of the change in age. Types of punishment are listed in clause 4 of BNS. 4B reads imprisonment for life, that is, imprisonment for the remainder of a person's natural life. It seems to categorically say imprisonment for life means for the remainder of one's life. But the term imprisonment for life is used in some clauses like 101, whereas the term imprisonment for life, which shall mean the remainder of that person's natural life, is seen in clause 102 and some others. To compound confusion, clause 6 says, in calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years unless otherwise provided. There was a mention of the section relating to mob lynching. Clause 101.2 deals with mob lynching without using the phrase mob lynching. It deals with 5 or more persons acting in concert, committing murder on ground of race, caste, community, sex, place of birth, religion, personal belief, or any other ground. Note the absence of the word religion. If you think the word community will cover religion, why are religion and community mentioned separately in clause 194? What is the point of the omnibus phrase, any other ground? If any ground will attract this section, why mention any specific ground at all? The phrase court of justice occurs in 43 places in the Indian Penal Code. In BNS, court of justice becomes just court. The phrase of justice has been omitted. Is this meant to convey any subtle message? One of the most glaring errors I noticed is in the general exception relating to intoxication. IPC has a provision which essentially says nothing done while under intoxication is an offense, provided the intoxicant was administered forcibly. BNS has replaced the word provided with the word unless. It reads something like this: nothing done while under intoxication is an offense unless the intoxicant was administered forcibly. This means that if someone spikes your drink and you then commit an offense, you are guilty, which is not what is meant to be conveyed. In fact, it is the very opposite of what is intended. If you find it difficult to wrap your head around this, think of these further dumbed down examples. Nothing is an offense, provided it is done with good intent. Nothing is an offense unless it is done with good intent. In 1631, a Bible was published in England, and it came to be known as the Wicked Bible or the Sinner's Bible. It had omitted the word not in the 7th commandment. Instead of saying, thou shalt not commit adultery, it read, thou shalt commit adultery, which is not exactly what was revealed to Moses on Mount Sinai. Now, that can be excused as a typographical error, a blunder by the compositor. But the inaccuracies pointed out in BNS above are more serious, indicative of loose thinking, which has no place in a piece of legislation. Many of you may be aware of how a dairy company in the USA had to shell out $5 million because of a missing comma, known as the Oxford comma, in a piece of legislation. In the Statement of Objects and Reasons, the Honorable Union Home Minister, while introducing the BNS, acknowledged that IPC was the work of the first Indian Law Commission under the chairmanship of Macaulay. Would it not have been in the fitness of things if drafting the new acts had been entrusted to the Law Commission, which is traditionally headed by a retired Supreme Court judge or a Chief Justice of a High Court? The Law Commission's website proclaims its vision as reforming the laws for maximizing justice in society and promoting good governance under the rule of law. The terms of reference for the Law Commission mention review or repeal of obsolete laws and revising central acts of general importance. Which central acts are of greater importance than the major acts? But the task was entrusted to a committee for criminal reforms constituted by the MHA in May 2020, with 3 academicians or scholars, a senior advocate, and on the judicial side, hold your breath, a retired district and sessions judge of Delhi. Finally, will the new acts fall foul of Article 348 of the Constitution? This article says authoritative texts of all bills and acts shall be in the English language. Of course, the text of the acts is mostly in English, but the titles use Hindi words and the Hindi words Sanhita and Adhinayam occur repeatedly in the Act. Of course, the article says the power vests in the Parliament to make a law to authorize text in Hindi. But in the absence of such a law, how will these bills pass muster? Legal scholars of excellence with sharp legal acumen have seemingly spent three years over these proposed criminal reforms. It is reported that suggestions were received from the Supreme Court, from 16 high courts, 5 judicial academies, and 22 law universities, apart from a large number of MPs and MLAs. There are many positive and progressive features in these new courts, no doubt. All this work should not go waste. But I think the best thing will be to modify the existing acts, incorporating the proposed changes rather than having new enactments. And this task can be entrusted to the Law Commission to make the modifications. I doubt that this will happen, but there is no harm in hoping wishes will be horses. Thank you.
Thank you. Thank you very much, Mr. Ramanujam. This is for putting things in the perspective. And now I will, for want of time, I will quickly go to the next speaker, Dr. Vikram Singh, former DGP Uttar Pradesh.
Mr. Ramchandran, sir, good evening. Mr. Kumaba, sir, good evening. Good evening, ladies and gentlemen. For paucity of time, I'll go into the rapid round and in fast forward mode. And as has been pointed out by earlier speakers, that as against 1,059 sections, there are 1,160 clauses that need to be addressed. And one Supreme Court senior lawyer mentioned that there are hundreds and hundreds of case laws in respect of all the sections that we've had. I will go into the basic, what was the wish list of the police, what was the wish list of the judiciary and the society, and then I will see very good observations have been made by learned speakers before me. I would say that there's something that was akin and talked about, love jihad. Clause 69 addresses that issue, and wonder of wonders, when there were parliament questions at how many cases of love jihad have been registered, the BPR, the NCRB mentioned that there was not a single case in the country in respect of love jihad. But now the specific provision, I feel, to put things in perspective, we will have the registration in appropriate sections to identify the problem and go ahead. Mob lynching was another contentious issue, and that has been addressed as mentioned by other speakers, and I'll stop at that. But the problem in respect of section 124A vis-a-vis 150, clause 150 of the Bharatiya Nagrik Sanhita, that goes to show that there are two words that I used. One is waging war against the government, and the other is waging war against the nation. Rajdroh and Deshdroh. Rajdroh, that is sedition, has been done away with, but Deshdroh has not been done away with. Now, to quote a specific example, there was a case that happened in the Northeast when somebody accused of sedition said to put so much of garbage on the roads and the railway tracks so as to cut off Assam from Siliguri and the rest of India. Now, this is punishable under the present act, and the penalty of 7 years plus with fine is very much admissible. So now there's a clear-cut distinction between Rajdroh and Deshdroh. Under these circumstances, of course, there are sweeping powers likely to be misused also, because the definitions are not very precise. Terrorism has been defined, and the claim is that all the ingredients and the international best practices of Makoka and Gujkoka have been incorporated in the BNS. Well, that remains to be seen. Now, what has been dropped? Adultery, 477, 309 IPC, attempt to commit suicide has been dropped. So far, so good. But 306, abetment to, as Sulkhan Singh ji had mentioned, my illustrious colleague, that if, as many of us are always faced, that when we dismiss a person, when we punish a person, which we normally do, it was a painful duty to do it, and there is an attempt to commit suicide or suicide does happen, in what way is the officer liable for criminal prosecution because there was no mens rea? Similarly, when we come to the Criminal Procedure Code, Clause 173 is the most important that impacts every Indian almost. I think every Indian lodges an FIR or is a part of the lodging an FIR. In this section, Mr. Kumawas, sir, the word shall has been used 6 times. 6 times. So the intent is very clear whether the discretion is given, whether discretion is not given. In this case, sir, I would have been very happy and delighted if the preliminary inquiries were structured and examples were given to illustrate so that the points are well taken and it's not left to the discretion of a manipulative IO or the SO. And again, we have conducted online. Mr. KP Singh, sir, had very rightly mentioned that the word in writing was not mentioned. The first clause mentions online and oral. It is only in the subsequent part of this clause that is mentioned that it has to be reduced in writing and signed. But the emphasis should have been in the initial preamble of the clause rather than keep it subsequently. Now, do we for a moment imagine that what will be a deluge or tsunami of reports now that we open the floodgates of online? I would request the honorable members to think of a mechanism, how to filter the authentic. We do have a mechanism. But whether it will be workable, because anyone lodging a false FIR, there should be consequences. And again, the Criminal Procedure Code and now the Bharatiya Nagrik Suraksha Samhita, Mr. Sulkhan Singh would agree that there is no element of procedure in the title. It looks like as if it is the Bharatiya Home Guard, because Nagrik Suraksha is the Hindi term for the Home Guard department. It could be something like Bharatiya Nagrik Suraksha Prakriya Adhiniyam. The word procedure or prakriya needs to be introduced, therefore people should be aware that it is a procedural statute and not something that is absolutely giving you security. Now, there are important and landmark changes come, and like any contemporary law and history, the dust has to settle down first. And before the dust settles down, very important points have been made, and it is for Mr. Ramchandran to see that they are issued, incorporated, and then resolved. But to the question that the Criminal Procedure Code, the community service, it is almost like cosmetics. Hit and run cases, a very good aspect. And coming to the Bharatiya Saksha Bill, the Indian Evidence Act, the avatar of the Indian Evidence Act, it's good. The admissibility of digital and electronic record as evidence, we shall have the same legal validity as paper record. It broadens the definition of secondary evidence to include mechanical copies made. 23 provisions of the Evidence Act have been amended. But again, as one speaker has said, do we have the wherewithal? Do we have the systems to put it in place? Do we have the wherewithal in the forensic science laboratory? We, as it is, are almost at the breaking point. But when there will be the floodgates of fresh registrations, are we in a position to do it? Easier said than done. But yes, I have an element of optimism. There is thesis and there is antithesis, and from that emerges synthesis. Very valid points have been made, and I feel that the committee, the parliamentary committee, would debate and go deeper into it and see the best way forward. Thank you, Mr. Ramchandran. Thank you, Mr. Kumar, for giving me this opportunity. Thank you.
Thank you, Sir Vikram Singh, sir. I will also look forward to your assistance. Of course, the assistance of every other person who spoke so far and others who have not yet spoken in making this, the memorandum, which we have to do in the next few days very fast. So I will look forward to your guidance and assistance. Thank you, sir. I will, with the permission of Dr. Sarangi, I have to give 5 minutes to Mr. Santosh Mehra because this is a promise I had made to him. Santosh, please go ahead, but keep on stick to 5 minutes, please. Thank you.
Very well, sir. I'll be very, very quick. I think almost all the contentious provisions of the three codes have been covered. So I will not dwell upon them again. Quickly, I'll come to, sir, two important things. One is, sir, that we are finding that large number of provisions have been addressed, have been highlighted. So should the IPF focus on things which are exclusive to police, or all the provisions which are also going to be supported by other agencies? I would imagine that many of these things which were discussed today are going to be taken by human rights organizations, social media, civil society, legal bodies, etc. So probably I would feel that to avoid clutter, we should focus on things which are going to be enabling the police to perform its professional duties in a better way, and avoid things which are already being taken by other agencies or entities. That is one suggestion I would say. Then, sir, coming to the objectives which were very well highlighted by the acting chairman, Mr. Kumawa, sir, it talks of speedy justice, which includes speedy investigation in the first place, ease of doing things. So these are the things, sir, which we should leverage the stated objectives to the benefit of the police, sir. Now, few things that I will mention, sir. One is that at the time, the Supreme Court had asked the BPRND about 3 years back, which Mr. Umawati had also referred to in terms of geo-stamping and time stamping of the evidence being recorded. This includes the scene of offense, panchnama, statements of the witnesses, etc. Now, Supreme Court had already taken cognizance. I do not know if the judgment has been passed or not, but that is a great way of reducing the time. It can be done very quickly, and the time is wasted on a scene of offense can also be, very quickly covered because of the geo-stamping being done by the video camera. Then, sir, the body-worn cameras can also be utilized for recording the statements, audio, video thing, which will have greater acceptability. But I'm talking of leveraging technology for doing, basically including ease of doing things. And as I said, Supreme Court had taken, cognizance of it. It would have already passed the judgment or is in the process of doing it. Then, sir, we should also have online filing of charge sheets. As SPs, we have found that we really have to cajole, persuade, and even bribe the court clerks for filing the charge sheets, for getting the PRC number, CC number, SC number, etc. So there should be a provision for online filing of charge sheets, so you actually know that these cases, the investigation had been done and charges have been filed. Otherwise, after completion of investigation, we keep asking our IOs and the courts, because of the pending mounting pendency, and they also are accountable to their bosses. They sort of delay the filing of charge sheets. So online filing should be allowed. Likewise, sir, I also had mentioned about though there have been Supreme Court judgments also on this, all these matters of bail should be necessarily through video conferencing. Still this practice of prisoners' UT is being produced in the court should be totally dispensed with. It should be necessarily by video conferencing. And we should also explore the possibility of trial, as was done during the Corona period, through video conferencing. That will be also contributing to what is called ease of living things, sir. And it will reduce manpower. Another thing, sir, already Mr. KP Singh had mentioned about plea bargaining, and also, in fact, I had conducted a lot of workshops on plea bargaining in Hyderabad. This should be probably made mandatory before filing the charge sheet in certain cases, which are not very serious. Already it is, the provisions are there. If plea bargaining is made mandatory, at least in a limited way in certain cases, it will reduce the pendency of cases in a very big way. Of course, incorporating or amending the changes which were being suggested by Mr. KP Singh. So these and
thank you. Thank you.
One more thing, sir, I wanted to mention was that in large number of cases, our witnesses turn hostile. Even the victims of rape cases, whose statements have been recorded under 164 CRPC, are turning hostile, resulting in a lot of wastage of time. So perjury, cognizance of as perjury should be made compulsory in all such cases where 164 statements have been recorded, particularly in serious cases like this. So, and also, sir, we need to have NHRC, SHRCs also on our side. Many of these provisions which are discussed are, as they are bordering on violation of human rights. We should try to have them also on board to take it with the government. So these were a few suggestions I would give. I think I have not exceeded the time limit given to me.
Very important suggestions, very useful. I would request you to write them down and send them across to me also. Now, I go to the next very important part of today's workshop, that is hearing the rest of the audience. And I would request Dr. Sudhanshu Sarangi, DGP from Odisha, to moderate this and also conduct the rest of the program from now.
Good evening, sir. Regards to everyone. It has been very enlightening. Mammoth task being undertaken by the government to completely change all the three major laws. As far as the Indian Penal Code or its change is concerned, definition of crime and prescribing punishment is always political choice. But as Mr. Ramanujam was saying, I was just thinking we should suggest that the numbering of the sections in the Indian Penal Code need not be drastically altered. That would really be dislocating police work, court work, past cases, present cases, CPTNS. There's large implications. The changes of numbering in CRPC and Evidence Act is all right because they are not used on a day-to-day basis. So we should, from a police perspective, suggest that. The purpose of investigation is to gather admissible evidence. So in most countries now, they are combining two laws, that is the CRPC and IPC into a single law. In UK, you have the Police and Criminal Evidence Act. If you tell me to record a statement in a particular way, you have to tell me that it thereafter becomes admissible. Or as Mr. Mehra was saying, there should be a perjury section or a penalty attached. We need to discuss how custody will be managed and our police perspective on that. We need to, I was expecting that prosecution will be completely changed because it's a missed opportunity. A lot more of powers should be given to prosecutors. We need to ensure that 80% of police cases do not go to court. No country in the world has so many cases going to court. And if you have so many cases going to court, you will have backlog. You have started with plea bargain, very welcome development, but they need to be discussed along with what is the kind of prosecution that would take us out of the current crisis that we are facing as police officers in handling the criminal justice system. Recording of statement, again, we have gone back to same thing, saying contradiction, corroboration, no provision of perjury. There is virtually complete omission of commissioner system in the entire CRPC except for one particular or two sections. As far as preventive powers is concerned, they're just not mentioned anywhere. So that is, as Mr. KP Singh was pointing out, that is something that I noticed. There are many other issues relating to just police perspective. I'm little, my summary of the whole thing would be it is a missed opportunity, a lot more was possible. With these opening words, we will go to the members who have requested for time to present their views. And then thereafter, of course, Mr. Ramchandran has the mammoth task of compiling them. Mr. Dixit from the Indian Law Institute, you wanted to submit something? Please go ahead.
Thank you so much, sir, for giving me this opportunity. I think most of you have already summarized all the things very clearly. I just wanted to add one or two more important points. Any criminal justice system without the element of justice becomes criminal system. And why we introduce the concept of Bharati Nyaya Sanhita instead of Bharati Dand Sanhita, the previous version, is because we are currently focusing more on the justice element than the Dand element, that is a punishment element. Point number two is that since we already had this provision of plea bargaining, which therefore means since we were not able to utilize this particular concept as was introduced in the earlier 21st century, that doesn't mean that we do not have the third way solution out. We can also have the concept of pre-litigation mediation. Now, this concept of pre-litigation mediation has already been in place in many of the commercial court transactions, some ADR related matters, and also like consumer court matters. As in when we see the global geographies on this, we see that the criminal elements are also being considered as a part of pre-litigation mediation. And I remember the case of Dayavati versus Yogesh Kumar Gosain. When I was doing my BLLB honors from the National Law University Bhopal, I was given this task by MP Salsa to work on this part and see if we can have a criminal law with a pre-litigation mediation concept inserted into it. I think this can be one of the matter to be discussed by the parliamentary committee now. And the third point, as I just want to sum up, is that there are many provisions available in the current law, the BNS bill, but we need to mention that there are some good, there are some bad, there are some dicey elements. Good are those elements which, like many of us have, applauded the government for bringing into this particular aspect. And I was very lucky to be a part of this criminal law reform committee during my law school. And I think the suggestions which have been presented by the speakers will definitely gonna add some more value to the consultative exercise. Thank you so much, sir, for giving me this opportunity.
Thank you. I mean, I was also wondering why plea bargain should only start after police decides to bring the matter to court. Can we do it something before that? But along with that, we need to ensure that the more powers to arm twist criminals into admitting plea bargain or accepting plea bargain for some offer, the offer of lesser punishment. But this volume of cases going to court is not helping us, and it's a very valid point. Can we move on to Mr. Upendra Baghel, please?
So, good evening, sir. Can you hear me?
Yes, please.
Yeah, I'll go for 2 minutes because as many of the speakers have already touched, and I like basically most of the points have been covered by Dr. K.P. Singh, sir. But still, I feel that this look like an old wine in a new bottle. And some of the aspects are missing, particularly in the Criminal Procedure Code, which is the new law now. In this, focus should be there on how to improve the quality of investigation. So I think sufficient focus has not gone on that, including maintaining the chain of custody of evidence. And now new law in this thing, even access to counsel is given during the investigation to the accused. It will open a lot of things. So we police leadership have to think how to improve our quality of investigations. Same thing, judgments. When expeditious trials should be there, case management principles have not been followed. So how the judgments of the court proceedings to be done as quickly as possible. Otherwise, it will have a lot of backlog again. So with these two things, I will just end this one. Later on, I'll write a note on these, some more aspects I have. Thank you.
Thank you so much. I mean, I was also thinking why case management concept has not been introduced. It's a global concept and it should be there to reduce and coordinate. That's a very valid point. Dr. Iskumar, sir. You go next, please, Dr. Iskumar. You are muted, sir. Yeah, now, okay.
Thank you, Sudhanshu. Actually, honestly, good evening, everyone. I have not been able to study the provisions in the new acts, and so today has been a very enlightening day for hearing so many learned speakers. But so one point which I would like to make, which Mr. Ramanujam made and Sudhanshu also touched, sir. IPF must project to the parliamentary committee, if it is possible, to retain the old section numbers, sir. It is going to create a whole confusion among all police officers, judicial officers. You will have old cases under investigation and under trial among the old sections, and the new cases being registered under the new sections. I think it would take decades to remember the whole. So if this point can be made that YPC gets retained and the sections are altered or added or deleted wherever required. So that's the only suggestion I would like to make. Thank you, sir.
Absolutely correct, sir. In fact, I was also thinking as I went through the criminal procedure code, thanks to the orders of Mr. Ramachandran, my understanding was that possibly the committee has not been given a briefing on CCTNS and ICJS. They have still written about manual records, manual registers, everything manual, except for electronic data, which I think somebody has given them some briefing. They have not understood that police procedures have undergone sea change consequent to the implementation of the CCTNS system across the state and the interoperable criminal justice system. So that's something that we will have to tell the committee to relook at it and make changes to CRP. Our submission should be that as far as the IPC is concerned, please do not change sections. CRPC and Evidence Act, you can change sections, it will not matter. We don't use them on a day-to-day basis. Dislocation will be limited. Can we go to Professor Verma, please? Professor Arvind Verma.
Yeah, thank you. I'm going to make one brief point. The government has introduced all these new provisions under the large statement and claim that what they want to do is to do away with the colonial moorings, the colonial model that was inherent in all these laws done by the British. Now, I'm not very sure what really constitutes a colonial model. Many of these provisions which are there, we are ready to accept them. So it doesn't mean that we are accepting the colonial model. To my mind, the colonial model is inherent in the system. And the system is something where there are 3 points which are really crucial, which may not really be reflected much in the modification of these laws, but are very much part of the system of criminal justice that we have. So one of them is the lack of local accountability. There is no provision at all where a citizen complaint will be looked locally by some citizen board, which is independent of the police and the other quasi government apparatus. So we need a system of local accountability, and there are many, many models for that we can discuss. The other one is that the British introduced the system of transfer and posting, which we all know has really been the bane of Indian policing. And that was done with the express idea that officers should not be able to develop any roots in the community because they feared that they will then become a problem for the British, and they will probably have more interest for the public rather than for the British interests. Now, this is against all forms of community policing, where we need officers to stay within the community, know the community, work with them, gain their acceptance, gain their consent in order to function. But we are maintaining this transfer posting system without any change from the British period. So that also needs to be addressed. And lastly, the major design of the colonial model is a complete centralization of power and authority. And it is inherent in the police leadership, the command, the kind of command that they exercise. Also, in the ministry, in the centralization of the ministry through which the police apparatus is controlled. So today, for example, we have a home ministry that is actually engaged in operational matters, which they should not be, that's not the jurisdiction. They should be making it concerned only with policy and some other matters. So I think these 3 points, which is the lack of local accountability, the transfer posting system, and the centralization of operational matters by home ministry is something that we should also mention, that these need to be addressed in order to get away from the colonial model, which is not being addressed by sort of cosmetic changes in the laws that we are talking about. Thank you.
Absolutely agree, Professor Verma. I think all these 3 issues are very, very important. They should have been actually recommended by the National Police Commission. They ended up recommending something.
Yeah.
But they are more relating to the structure of policing, making them locally accountable and the organizational structure, devolution of powers, etc. I do not know whether they would be consistent.
I'm trying to draw attention to the fact that the government has introduced this bill under this claim that what they want to do is to do away with the colonial model. So, we should challenge them on this. How are you doing? What is the colonial model? What are its characteristics, and how you are trying to do away with them?
Sir, the biggest colonial model that we should address here is statement before the police is not admissible in evidence. This is the biggest colonial legacy that we have inherited. It does not exist in any democracy. And if they had allowed us to redraft the bill, we could have given enough safeguards to collect statement or record the statement of accused without, violating rights of citizens. Instead of moving forward,
I think, Sudhanshu, we don't carry that much of credibility with the general public. That today we can say, let's confession before.
We should have been given an opportunity to move forward rather than retain the colonial legacy.
I agree with that. I agree with that. All that is the bane.
How much more longer?
All that is the bane because
Sudhanshu,
sorry, there are very, very clear models how you can ensure that giving power to the police to record statements will not be misused. And this is what has happened all across the democratic world, that they have moved on from the old system into a new system. If we are decolonizing, we should have decolonized in respect of this very critical aspect of policing in terms of custody management, custody officer, rights of the persons in custody, and recording statements of the accused in custody.
Right.
That is the most important component of decolonization.
About recording of a statement, I would like to say something.
Sir, please.
As we all know, statements are recorded in the police stations. Even when, someone, SHO goes or inspector goes to somebody's house, he just takes notes only. And he records, statements much later, after days and days. And he records as per his, interests. So why can't a copy of the statement be given to witness who has given his statement? A person like me or person like all of you, we should sign that with date and time, and a copy should be given, so that, when I go to court, I know that this is what I spoke. I have appeared in the court many times, and the SHO recorded whatever he wanted, in some cases. So at least this we can recommend to the standing committee, that a copy of the statement must be given, number one. And those who are literate or rather educated persons or graduate, they should be allowed to sign their statements. I worked in the CBI and I found that even general manager's statement, we were not taking his signature. Later on, some inspector will write what he wants to write. So this may also be considered by those who, I think we are going to.
Sir, I'll put it like this. Yeah. I'll put it like this, how other countries have sorted it out.
Please.
When you record a statement, you need to have safeguards. For example, the person should not be in the custody of the officer under who is recording the statement. Number two, there's a lawyer present. Number three, it is recorded in a tamper-proof format. And number four, court listens to it, and if court finds that this is repressive, or the officer was blackmailing, or the officer was shouting, or the officer was giving wrong incentives to confess, then the statement becomes inadmissible. So what they have done is they have said this: you police officer, behave well, and we will accept your work. What you are saying is, you police officer, you are bad. No matter what you do, we will not record your statement. So this colonial legacy has been retained. On the side of the statement of accused, again, not being recorded at the spot in a contemporaneous manner, not giving him adequate explanation, oath, making him answerable to perjury. These are the two critical components of the colonial legacy which have been perforce copied as they were in the old CRPC. And then what is decolonization about? I mean, these are the two critical components of police investigation. As a police officer, I am only interested in this and nothing else.
See, the Supreme Court mandated and monitored project which I was talking about on geo-stamping and time-stamping addresses this issue, and is a step in this direction. It is being done under the director of...
Sir, may I request others also to allow? to speak.
Yes,
Yes,
just
sir,
one
Mr.
second.
Damodar. Mr. Damodar, IG from Andhra Pradesh, he has been waiting for a long time. Yes, please.
Just 1 second. The geo stamping and time stamping takes care of the place where the statement is recorded and the time at which it's recorded, and it will become admissible in the court of law because of the audio video thing.
You are right, sir. This briefing should have been given to the committee that we have a CCTNS system where this can be done. But the briefing, they have not requested for the briefing from NCRB, and possibly no one has given the briefing, creating this confusion. Can we go to Mr. Damodar, please?
Yes, sir. Thank you very much, sir.
Waiting for
Now, I will make 3 crisp points. Number 1, it is not only the police, there are 2 other agencies which are the investigating agencies, like SFIO under the Companies Act and Enforcement Directorate under the PMLA Act. They also have to follow the same procedure. But the magnitude and the quantum and the quality of offenses they investigate cannot fit into the procedure. You cannot have same procedure for a simple hurt and an offense that is being investigated by the SFIO or Enforcement Directorate. To substantiate, I'll give an example. Bhushan Steels. By pumping in 38 lakhs, they have swindled more than 4,000 crores. SFIO has investigated. A multidisciplinary body prepared a charge sheet of 70,000 pages and 238 accused. If they follow the present procedure of the same procedure for the simple hurt, none of the lawyers representing the accused, none of the accused will be alive by the time the trial concludes. Is it necessary for us? Should we not look at it drastically? Dr. Ramanujam has mentioned about radical thing. We should attack the fundamentals also. That's what I feel. Secondly, so separate procedure for separate types of offenses, arrestable, non-arrestable, cognizable, non-cognizable. We have to transcend beyond this classification of offenses. Terrorist offenses, you can't have the same procedure. If a Naxalite, I am witness to a murder of being committed with Naxalite, should you suppose me to the same procedure? And do you say that I should be examined as a witness in the presence of the Naxalite? So taking into account the emerging newer crimes, graver crimes, which are globalized, you need to have a separate procedure. I think the committee should look at it fundamentally. Secondly, that is the reason why I have given the case of Bhushan Steel. There are many such cases. Secondly, what is lacking in this is victim care. Victim is not at all associated at the state. Once the state takes over, victim is kept aside. But in other countries, in the European continent and in America, victim has the right to associate himself in the investigation, in the trial, etc. Victim care is not there. Similarly, victim compensation, though it is there in ad hoc basis, our fines are so meager, 100 rupees, 10,000 rupees. It is a ridiculous to say that imposing 10,000 rupees and Vijay Malaya. You have to impose substantially, taking into account the paying capacity, and the court should have the provision to directly order to the victim. Only then the victim will be justified. This is there in progressive countries. Third thing, we don't have to reinvent the wheel. Many such progressive recommendations have been made by a Malimut committee. Malimut committee has taken long. They have consulted all the stakeholders of all the shades of opinion in the country, and also eminent jurists from abroad. And that was also constituted by BJP government, Mr. Advani, when he was the home minister. Why it is consigned to limbos? Let them rake it up. Read whatever can be implementable. So this is how I feel. Similarly, whatever things that we make about, as long as the police have no autonomy, you are subject to local MLA or local minister, the entire investigation process will get diluted. For that, the way judiciary, local subordinate judiciary subject to the High Court, there must be an alternative body. Even if they don't accede, we should ask for it. The politicians may not accept it. They would not like to surrender their control over the police, but they should ask for it. Secondly, Section 125 CRPC, I am closing it. Maintenance. 125 CRPC led to Shabano case. In the new CRPC bill, they have given the power to judicial officer. One of the distinguished speaker has mentioned it. It should be given to the executive magistrate. Not only the public order and also this. Otherwise, now these changes are not going to lead to law and order. They are going to lead to law against order. Thank you.
Okay. So Damodar, there is a compensation provision that has been added this time. This is much better than what existed earlier. That's one of the good things that has happened.
That's not sufficient, sir. Taking into account the inflation, I die in my road accident,
please
if
look
as a
at
victim, if I am paid 10 lakhs to my wife, what does it happen? A fellow who comes in a Mercedes Benz,
No.
and when it comes, it goes to the treasury. Treasury gives it to me. It takes 6 months.
Go to 292, 293. Anyway,
Yes, sir.
can we move to Mr.
Thank you.
Alves Mangalam, please?
Am I audible, Sudhanshu?
Yes, sir.
Thank you, Sudhanshu. Thank you, IPF, for giving me this opportunity. I would just hurriedly add 3 points, as most of the points have already been added by learned earlier speakers. One, the defect that was earlier is continuing. There is no option except registration of the case, either at the police station level and full prosecution complete the trial process in the court if the magistrate takes cognizance. However, in practice, most of the police officers, they do counseling and mediation, at least in petty cases. As such, we are already having more than 5 crore pending cases before judicial system. The new provisions will add many more crores. So unless we have a definite system with adequate safeguards to dispose of smaller petty cases, trivial cases at the police station level to begin with, or at the senior police official level, or at the magistrate level, JMFC, judicial magistrate first class level, that in the beginning itself he tries to bring the two parties together, and if there is any chance of accommodation among them, among the two parties, it should be disposed of in a summary manner. I have, as director prosecution, I have talked to many magistrates and judges. They are always in the favor of full trial for variety of reasons. The second point that I would like to add from victim's perspective point, respected Kumawat sir has touched upon it about giving a copy of a statement to witness. I am of the opinion that the whole bunch of charge sheet papers or investigation papers should be given to the victim so that victim can pursue its cases. In the current CRPC, we had used a provision in section 173 to give a copy to victims, but since that was just a notification, not a very specific provision. So I'm afraid that most of the SHOs, at least in my state where I successfully got the notification issued, are not providing copies to victims. In the absence of papers of the victim, there is no level playing field between the accused and the victim. While under current section 206 provide for giving copies of all the charge sheet papers to accused, the same privilege is not with the victim. The complainant does not have any paper even if it wants to oppose the closure report. So I am of the opinion that not only witnesses, but victims also should have all the papers. And attending provision all that to that would be to allow private prosecutors. As such, we all know what is the level of prosecutors in practice. Many victims are not happy with the performance of prosecutors. Public prosecutors do not feel themselves answerable in any manner to the victims. They don't even they don't even share the dates of the next hearing. They don't even share the progress of the case. Although there are some provisions in some acts like SC/ST Prevention of Atrocities Act, but even in those acts, it is not generally followed. So I am of the opinion that there should be a specific provision, enabling provision. Situation have changed since 1861 or even 1973 code. Third point I would like to add about the status of directed prosecution in the present section 25 and the section the provision was very ambiguous. Certain states have made certain state specific amendments. Prosecution is one of the weakest link in our criminal justice system, and in the current draft, the present section 20 has made the situation even more difficult. I would like to read, if time allows, proposed section 20, subclause 7, 8, and 9. Subsection 7 says power and function of director prosecution shall be to monitor cases in which offenses are punishable for 10 years or more, or life in prison, blah, blah, blah. However, subsection 8 says power and function of deputy director of the prosecution shall be to examine and scrutinize police report. What does this mean? That the deputy director will examine the police report and monitor cases in which offenses are punishable for 7 years or more, but less than 10 years. So what is this police report? If the police report, as we understand in the current CRPC of 1973, then police report is the report filed under section 173. Something that which is not in the current prevailing system. In the new, we want. However, the same provision is not there for the proposed draft for the director prosecution. So it means the graver offense will not be scrutinized. Only the medium type offenses will be scrutinized.
Sir,
so these are the 3 points.
Right, sir. I would just tell you that this entire prosecution was, could have been redefined, reorganized, utilizing this opportunity. We have really not, I don't think much thought has gone into it. We need to strengthen the prosecution system and come up with a system where number of cases going to court has to go down. And that is something that has not been addressed. And I would be very happy if you only focus on prosecution and give a note with your background in director prosecution and all the points that you are saying. Also a bit of a comparison of, how this problem is handled in other countries.
Sure, I will give.
Very good.
Earlier they had provided for an advocate of 10 years practice as a director advocate, a director prosecution. Now they have added an advocate of 15 years of practice or a session judge. This means that other officers of the secretary rank or above, they will not be eligible. So again, it will require state specific amendments to include an IPS officer or an IAS officer as director prosecution. Director prosecution is an administrative post of the state government. They have lot many functions to do.
UP, the High Court has struck down the appointment of an IPS.
Yes, but in MP, as early as in 2013, they had made a state-specific amendment whereby they have authorized an IPS officers as well as IAS officers also.
Sir, and we will end because we have run out of time.
Yes, yeah.
Mahendra
thank you for providing this opportunity. Thank you.
So kind of you, sir. Mahendra Kumar, and after that I'll pass on the platform to Saini to give the vote of thanks. Mr. Mahendra Kumar from NSG. Yes.
Good evening, sir. Sir, I would like to add only one point, sir. We have to incorporate to make the law available, make the judicial system easily available for all the aspirants or all the victims by incorporating evidence act in such a way that evidences produced in the court by the lawyer must be having a time limit, and due to deliberate diversion by a lawyer, they are getting delayed, and justice system is getting delayed due to the evidence act, and evidences must be produced evidence must be validated if required. So the court should not take more time. Jain, sir.
Thank you. Mr. Ramachandran, sir, it's your turn now. Thank you so much.
Well, thank you. Thanks a lot, Sudhanshu. And now I'll straight away go to Shaini. I'll request Shaini to quickly sum up what has been discussed so far and propose the word of thanks. I would also once again request all the speakers and also others who have not been able to speak for want of time, to submit small little notes. You can send them to the email address which you have now. And as soon as possible, because we have very little time, please try to send it in the next 2 days if possible. So over to Shiny.
Thank you, sir. Good evening to all senior officers present, colleagues and participants. I am thankful to Sri Ramachandran sir for giving me this opportunity. I have been asked to sum up the deliberations today. And as Sri Ramachandran sir said at the outset, the objective of today's workshop was to identify the practical issues that police officers will face on passing of these three new laws, and to list out the concerns and proposed suggestions before the final act is enacted. Sri Ramachandran sir, I'll straight away go. This has been like a very marathon kind of a session, and each of the speakers should have been like given half an hour to 1 hour. So in such short time, lot of detailed deliberations had happened, and I would like to sum up in the 10 minutes that has been given to me. Sri Ramachandran sir, in his opening remarks, expressed certain concerns about the potential of the new legislation to unsettle the settled judicial positions, the issues that may arise in the renumbering and reordering and reclassification of the legal provisions. However, he clarified that the endeavor of this workshop will be to thoroughly integrate each of the proposed provisions in the three bills, critically, so far as its impact on policing, and the IPF will use this opportunity to consolidate the concerns and suggestions that have come out in today's deliberations and take it before the parliamentary committee. Sri M.L. Kumawat sir, in his brief address, stated that the objectives of the new bills are laudable, but the infrastructure is lacking in the field to meet these objectives. He stated about the Terrorist Act being already dealt in UAPA and the organized crime being dealt in special laws, and suggested that these both terrorism and organized crime should be dealt in special laws rather than having it in IPC. Sri Kumawat sir also mentioned about police remand, which has been subsequently clarified by many speakers later. He also told about mob lynching, the new provision on mob lynching that is in BNS, with punishment up to 7 years and no clarity on who is. There are two kinds of punishment given, and there is no clarity on who is to be given 7 years and who is to be given life imprisonment. So this he raised as a major concern. With respect to adulteration of food and drugs, he pointed out that many states, taking into consideration that such adulteration can lead to death of persons, many states like Odisha and UP have incorporated life imprisonment for adulteration, whereas the new bill has proposed less 6 months to fine for this, which he proposes to reconsider. He also expressed concern on the sedition section, which is retained in another way, 124A and 150, where subversive activities have also left a lot of ambiguity in law. Now coming to Sulkhan Singh sir, he started off with the heartening note to say that the name Indian Penal Code 1860 being replaced with the new name of 2023 is a welcome move, but expressed a little disappointment that not much of a big difference between the old act and the new act. He suggested the act to be renamed as Bharatiya Danda Sanhita, which was subsequently countered by the law student Dikshit, who spoke from Bhopal, and he explained as to why the justice part is to be retained in the penal, in the new legislation. So there are like divergent views on this, but it is for the parliament to legislate on this matter. He also suggested about abolition of death penalty, which was a recommendation of the Law Commission, which has not been considered in the new draft, and proposes that the IPF should include it as one of the recommendations, that the punishment should not be sort of vindictive when it is imposed by the state. He also discussed about forfeiture of property and rigorous imprisonment to be removed as punishments in the new BNS. After explaining the reasons, the sentencing discretion that is at present in the system, this has not been dealt in the new CRPC. The discretion, he suggests, that has been given to the judges, the huge discretion which the Malamat Committee and the second ARC had recommended to be curtailed, remains as it is in the present draft also. So he was suggesting a minimum and maximum punishment to be prescribed to exercise this discretion by the judges. Section 1, he also elaborated on Section 124A and the detailed discussions of the Supreme Court of India in Kedana case, and where the Supreme Court dealt with these provisions in detail, but did not struck down the provision. But there has always been demand from civil society on it being taken down, but the provision is retained in a different form in the new Act. He also suggested an offense, a separate offense to be included in the IPC, where a superior officer or an officer in position of government seeks a sexual favor from a subordinate or any person in return for an official act to be done. He also pointed the attention of the group to Section 266 in the BNS, where when an order is passed by a judge and it turns out wrong, there is 7 years imprisonment which is provided for. So he said that this affects the judicial independence and this provision needs to be reconsidered. I think that is a point well made. With respect to fraud and forgery sections that are in the new Act, he said that the word dishonestly and fraudulently to be removed. I do not know to what extent these provisions were just making a false document itself become punishable. So this need to be deliberated further before making any recommendation on this count. Section 350 and 351 in the new Act, he said, which curtails free speech, requires more critical analysis and amendment to bring in more of motive and intention. Abetment to suicide, which is in 105 clause, have been discussed by 2 of the speakers, where they said that an officer's or one person's act may lead to abetment, not necessarily because the person has abetted the act, but maybe because of the mental condition of the other person. So this clarity with respect to what acts will not amount to abetment has not been clarified in the new draft. He also suggested section that there should be a limitation period for section for application of Section 498A and 304B rather than keeping it open all throughout. He also wanted a sort of an equivalent of sodomy section to be retained in the new draft, which he pointed out has not been included in the BNS. Organized Crime and Terrorist Act, as suggested by the earlier speaker, he also proposed that it should be dealt in special law and not in IPC or BNS. Dr. KB Singh sir, in his address, I should say that his address was very concise and precise with specific recommendations that was shared with the group. The first being the inclusion of commissariat system in the new draft, where in the new draft of CRPC, and including DSP and above to be included as special executive magistrate, like in other department officers where the gazetted officer can be appointed as special executive magistrate. He suggested that instead of SP and above, this should be DSP and above. The suggestion regarding handcuff is a very valid suggestion, because the Supreme Court had given detailed guidelines on handcuffing provisions in Prem Shankar Shukla versus NCT of Delhi and in Citizens of Democracy and versus State of Assam. These guidelines are very rights-based, while giving police officers power to handcuff in situations which are practically that we come across. So these provisions are not known to field officers, but it should have come in part of a law. So he had suggested, as very rightly, that these guidelines issued by the Supreme Court should have been converted into the drafting of this particular section that deals with handcuffing. So, and he was of the view that the existing provision in the CRPC actually curtails the power of police officers because it limits handcuffing to certain offenses, because rape, murder, organized crime, economic crime, all these offenses have been defined in the handcuffing provision, whereas there is no such distinction of heinous or grave or petty in the Supreme Court guideline. Even if it is a petty offense and the accused person who is being arrested is showing dispensation to cause harm to the police officer or his colleagues or to himself, the Supreme Court had permitted handcuffing, which in this new draft has been taken away. So that is a very valid point that he has pointed out. The existing provision regarding medical examination of arrested person every 48 hours, if he is remaining in police custody, is absent in the new draft, which he proposes should be retained. And this has been included in the CRPC after amendment, after directions of the Supreme Court. So it's better that we suggest that this is retained. He also pointed out about security and security for keeping peace provisions being referred to the judicial magistrate instead of executive magistrate, which is the present which is in the present CRPC, and suggested that the old provision regarding executive magistrate dealing with security of peace should be retained. Regarding the language of the text in 173(1) of the new CRPC draft, two of the speakers had suggested including after orally the word in writing to be included in the first proviso itself to 173, which is a very valid point. And again, with respect to 173(3), where preliminary inquiry has been provided, little unsettles the settled position in Lalita Kumari. So as he had proposed, the draft clause with respect to 173(3) can be fine-tuned to include the detailed provisions as what Supreme Court had suggested at the end, by including matrimonial cases, offenses reported after whatever, and all those things. Prosecution of public servants by on a report by superior officer, and sanction of prosecution not required in some in such instances, which is provided in section 175(4), wherein a judicial officer can take cognizance without a sanction of prosecution if the report is submitted by a superior officer. This seems draconian, as pointed out by Sulkhan Singh sir, and violates the protection that was already there with public servants at present. So this is a recommendation worth to be considered, to be made. With respect to the duration of the police demand, there has been a lot of misconceptions on it being, which has been coming out in a lot of articles also, but subsequent speakers have clarified that there's a problem more with the language and grammatical error rather than with respect to the 15 days. But the remand period, Sulkhan Singh sir also suggested that remand period in heinous offences, this 15 days should not be a blanket for all kinds of offences. He suggested that the 15 days period should be extended to 30 days in case of 30 days police remand in case of heinous offences. He also brought to the notice that the word "other than" in police custody word has been omitted, which has led to a lot of ambiguity. This is also a very valid point. Plea bargaining which has been launched with a lot of fanfare, he said, is impractical because there is a conviction stigma and disqualification clause in future assignments. So he suggested that while retaining plea bargaining in the new bill, there can be a release on probation and taking out the disqualification due to the conviction, because you are pleading guilty and is being convicted. So this is also a very valid point made by KP Singh sir. Victim compensation, relating to victim compensation and the definition of a victim, which is a very valid point that he made, that the definition of a victim is connected to being charged in an offense. So if you looked at the earlier CRPC also, the definition was the same. The definition of the victim was connected to somebody who has suffered a loss or injury caused by reason of act or omission for which an accused person has been charged with an offense. This language has been there in the earlier CRPC also, and which is repeated in the present draft also. This is required to be changed because a victim is a victim, irrespective of somebody being charged or not being charged. He also brought to the notice, KP Singh sir also brought to the notice about the misconception regarding the concept of commutation in section 4, new clause 475C, which needs a redrafting. And he also suggested made a very good suggestion for bringing the reducing the load of pending trial cases, which is that in all cases where punishment is up to 2 years, all those offenses should be made compoundable. So this is a good suggestion. And he also expressed concern about the rights of the unborn child, where miscarriage of the child caused by the mother has been made compoundable in the new BNS with reduced punishment. We are thankful to Sri KP Singh sir for making very valid and concise and precise observations and comments and suggestions. Sri Umabati Sataru sir, while making his comments on Indian Evidence Act, stated that the definition sections need to be elaborated in respect of digital evidence, which is to be redrafted as per the new IT Act, and that the definition of export should include all the other exports that the police is dealing with on a day-to-day different kind of cases. He also suggested sections 39 of the new Bharatiya Sakhya Bill to be redrafted in tune with the Identification Act of 2022. With respect to audio recording evidence in CRPC, he suggested that there has to be empowering provisions in the Indian Evidence Act also to make these things admissible during trial. He also made suggestions regarding detailing of procedures with respect to dying declarations in the new draft Evidence Act. He also flagged issues with respect to existing section 114A relating to presumption as to the absence of consent, and section 151 indecent and scandalous questions. He suggests that amendment is required in the new version of these two provisions. Sri K. Ramanujam sir, who was former DGP Tamil Nadu, gave a very enlightening address. He said while the old order was expected to give rise to the new order, after going through the acts, he felt that the old order is retained and only the sequence has been changed. He feels that substantive changes have not happened, and because substantive changes have not happened, he felt that there was no necessity of a new act. In effect, what he was suggesting was amendments with respect to the new provisions that have been included could have been incorporated in the old act so that officers can, it will be easier for off-field officers to remember the order of sections. He also felt that the drafting in the new acts leaves much to be desired, and expressed disappointment at the omission of the word corporeal in the new act, and in retaining the provision with respect to rape of a woman if she is a wife and of and above 18 years of age, not being a rape. Sexual intercourse with a woman if she is a wife, not being a rape. He also brought to the notice the ambiguity in the imprisonment of life provision, where in some places imprisonment of life means the remainder of the person's life, and in other places, in some certain other place, there is a reference to imprisonment of life as something equivalent to 20 years unless otherwise provided. So this ambiguity has to be addressed. With respect to general exceptions, he stated the issues in definition of intoxication, where not having the word unless, there is much left to be improved in the definition of intoxication in the new act. He also said there are inaccuracies in the new draft which are to be corrected. and suggested that the drafting, so though that is probably not possible at this stage, that it would have been better if the drafting has been done by the Law Commission as it was done in IPC by the first Law Commission of India. After Sri Ramanujam sir, Dr. Vikram Singh sir had given his address. He said he stated that for each of the section in each of these laws, bills that have been put up, hundreds of case laws are available. So it could have been possible to incorporate what is the latest settled positions of law into the drafting of each of these sections. That would have been an ideal situation. He then went on to list out the wish list of the police, where he said that the Rajdroh has been done away with, but Deshdroh is continuing to be offense in certain way, and pointed out that this is little draconian in an independent India. All the speakers, including Sri Vikram Singh sir, was of the view that terrorism and organized crime were better dealt in special laws than in IPC. Abetment to suicide, which an earlier speaker had also brought to the notice of the group, sir was also the opinion that protection needs to be given so that if somebody goes on to commit suicide because of an act of yours, but triggering certain other emotions that are disproportionate to the act of the officer or the ordinary person, it should not be counted as an abetment. This is a suggestion well made. And preliminary inquiry, all the officers who spoke today were of the view that retaining little bit of preliminary inquiry in a divergent opinion with the Supreme Court in Lalita Kumari case is can be of practical use for the police, but this preliminary inquiry in which are the cases which this is to be conducted had to be well defined, which has not happened in the present draft. Dr. Vikram Singh sir also pointed out regarding the title of CRPC, where the procedure has not, that from the title it is not understood that this is a procedure code. So he suggested Nagarik Suraksha Prakriya Adhiniyam as an alternative to the existing title. Though he also pointed out about the good provisions that are there in the new draft, especially regarding community service, which has been given a legal sanction, though has been in place because of judicial pronouncements. Santosh Mehra sir in his intervention stated about importance of speedy investigation, ease of doing things as the objective, and about geotagging of police actions, body-worn cameras, and about leveraging technology, online filing of charge sheets, which, as Sudhanshu Sarangi sir had pointed out, is already in CCTNS, ICJS. Trial. He also suggested plea bargaining to be made mandatory in certain type of cases to reduce the workload of the courts, and perjury sections which are already there being practically applied when victims or witnesses turn hostile. So in the summary of these would be that most of the speakers were of the view that even if CRPC and IPC have CRPC and evidence have a different numbering in the new acts that come up, retaining the old sections in the IPC would be of a lot of help for police officers working in the field, so that they need not have to memorize the new sections, which would take time. Dikshit also, there was a law student who also spoke on pre-litigation mediation, which was a good idea, which would go in consonance with the plea bargaining that is already there. So both these together can take out a lot of petty matters which the court need not get bogged down in disposing, wasting a lot of years in disposing these off. Upendra Bagal sir had brought our attention on the need for some provisions for improving the quality of investigation in the new draft CRPC, where chain of evidence, case management, etc. could have been included in the draft CRPC that is put up. Ishkumar sir also pointed out about the importance of IPF platform being used to influence the parliamentary committee on putting forth the voice of the police officers before the parliamentary committee. And he also was of the view that IPC, it would be better if retaining the ordering of the sections is permitted in the Bharatiya Nyaya Sanhita. Dr. Arvind Verma sir was of the opinion that the new draft bills retained the colonial moorings, and he was of the view that the colonial system is inherent in all our laws and actions in independent India, and that's not just with India, but in other parts of the world as well. He demanded that there should be more of local accountability of police actions, and suggested about individual independent board being made available to look into these functions. He was of the opinion, so this probably would not get covered under the draft bill, because it is transfer and posting is already is a policy issue rather than a procedural or issue. But the point that officers at the present system, where officers are not eligible to be posted in the local area if you are from a particular area, this is a colonial mindset, because they don't want, they at that time the colonial masters did not want the police to get into the local issues, but the community policing and other systems show that the more you have the knowledge of the community and the area, the more efficient a police officer you can be. So that is a suggestion, that's a good suggestion, but probably not a part of this legislative discussion. We had a very illuminating discussion, and most of the speakers have brought out areas which the IPF plans to consolidate and take before the parliamentary committee. And I thank all the speakers, I thank all the participants on behalf of the IPF. And as requested by Ramachandran sir, each of the speaker or each of the participant who is attending this meeting is requested to send across a note to the IPF or get in touch with Ramachandran sir, so that because this we had only very limited time slot available. So if anyone wants to give detailed comments on with justification on what you had proposed, please send the note to IPF. Thank you so much.
Thank you very much, Shaini, for that. You have very succinctly summarized this, in fact not succinctly, in a very detailed manner. You have sort of summarized whatever has been spoken by our distinguished speakers. Thank you very much. It has been quite a learning experience this evening. I must thank every one of you who took out time, and quite a bit of time at that. And this has been quite a learning experience. And I hope that in the next 7 days or so, we should be able to dispatch this is a tall order, but then otherwise there is a feeling that the parliamentary committee may not accept our suggestions if they go ahead with the present timetable, unless they decide to give more time, extended time. But the fear is that unless we give our written commentaries or memorandum within the next 1 week, it may not go through. So I would request once again all the members, all the speakers, all those participants to give their views and send them to IPF through an email or whatever. And please do it as fast as possible in the next 2-3 days' time. Thank you. Thank you very much once again. Good night.
Mr. Ramachandran, I would like to thank you for organizing this webinar, and especially Shaini for her great grasping power. She summarized everything, whatever, spoken by every participant. Thank you very much. Jai Hind. Good night.